Have a seat and give us your name and address for the record, please.
Linda Redding, P.O. Box 784, La Plata, Maryland 20646.
Okay.
And I had mailed this to the clerk, but I don't know if she received it. To the Board of Appeals, courtesy of the clerk. I wish to comment about how the Board of Appeals conducts its proceedings in general and not about any specific case, and am simply providing verbatim the following Charles County Ordinance Section 297-417, along with the Cornell Law School definition of de novo. And Charles County Ordinance Section 297-417, Section C, second sentence says, all board hearings or appeals are de novo proceedings. Same section, paragraph E, says the board may reverse or affirm in whole or in part, or may modify the order, requirement, decision, or determination appealed from, and may make any order, requirement, decision, or determination that, in its opinion, ought to be made in the case before it. To this end, the board shall have all the powers of the administrative official from whom the appeal was taken. And the Cornell Law School definition of de novo, from Latin, meaning from the new. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court to hear the case. An appellate court hearing a case de novo may refer to the lower court's record to determine the facts, but will rule on the evidence and matters of law without deferring to that court's findings. A trial court may also hear a case de novo following the appeal of an arbitration decision. De novo review occurs when a court decides an issue without deference to a previous court's decision. Trial de novo occurs when a court decides all issues in a case as if the case were being heard for the first time. Thank you.
Thank you. Aye. Any opposed? All right, so let's move then speedily along to Washington's discovery. This is docket 1376. We have had a number of hearings on this matter. We heard from the county, we heard from the developer, we heard from the appellants, we heard a lot from the public, and unfortunately ran out of time when we were hoping to conclude the case. So this is the point in that hearing where the board needs to have a discussion about the merits of the case and decide what, if anything, we are going to do on appeal. I guess the first thing that I wanted to raise is a concern that was raised by the developer about whether the appellants in this case have standing as aggrieved parties. I know we heard from appellant Thomas Moorhead, who is an aggrieved adjacent property owner. We heard from Mrs. Tomanak, who is also an aggrieved adjacent property owner. We heard from Linda Redding, who is not directly adjacent but lives in close proximity, talked about her use of the roads to reach a nearby store and park. She expressed, as I recall, frustration about her attempts to talk during the Planning Commission hearing during the public appearance, but she was actually cut off by county staff when she was trying to make those comments. Jim Long is also one of the appellants. He was actually invited to speak to the Planning Commission, which is a very unusual practice for them at the time. But it seems to me that a number of the people who are on the list of appellants fall well within what I would consider the definition of aggrieved parties for purposes of appeal. And I would ask if our counsel has any specific thoughts related to law that he would want to share with us on this topic.
Well, once there is an appellant that has standing, then it's irrelevant whether other people who would like to participate as appellants would have specific standing or not. It's called carried back standing or tag along standing. And so at this stage, the board doesn't need to decide whether everyone who's participating has standing, as long as someone has standing. Again, you have someone who's an adjoining property owner, and under your rules, that person is considered to be especially aggrieved.
Okay. Any other comments about that concern that was raised on appeal? I know we heard from a number of other nearby residents who shared concerns and testified about their use of those, public facilities, and I appreciate the legal feedback. It's good to have someone to help kind of keep us on the straight and narrow when it comes to changing case law. I'm going to start off by just kind of sharing some of my thoughts on this appeal, and then, before we do any kind of motions, I would like to give an opportunity for everybody else here who's a member of the board to share their thoughts as well. On point 1 of the letter of appeal, I am persuaded that the applicant or the appellant is correct. The videos of the conduct of the Planning Commission do in fact speak for themselves. The initial motion to approve was sure to fail with a tie. The developer approached the county attorney, who improperly asked the Planning Commission to defer any decision. A vote to defer the matter failed in a tie, and the county attorney incorrectly asserted that a tie vote means no decision, which created an impasse. That impasse lasted until September 12th, when a different group of Planning Commission members considered the case and approved the preliminary plan. In effect, the county attorney helped the developer cherry pick or shop for a different group of Planning Commission members that would provide the desired vote to approve. And that concern was echoed by a member of the Planning Commission during their meeting on September 12th. The procedural errors made by the Planning Commission related to the case justify this Board of Appeals reconsidering the case, and the proper outcome of the meeting of August 8, after the tie vote to defer, was, in my judgment, to deny the preliminary subdivision plan. I'm going to skip point 2 and go straight to point 3 of the letter of appeal. I'm persuaded that the appellant is correct on this matter too. The former rules of procedure for the Planning Commission did not adequately allow for public participation. Prior to the initial hearings of the case, both the Planning Commission chairman and the county attorney have instructed public members that they are not permitted to speak on active agenda items during Planning Commission meetings. The issue was debated at length during the meeting on September 12th of 2016. The result has been a sweeping change to the Planning Commission rules of procedure for future cases, which is a good and important change. Thankfully, we were able to hear from the public during our process, and the testimony and evidence presented during our appeal process was compelling. Critical new facts were introduced into evidence and was essential to my analysis of the second point of appeal. On point 2 of the letter of appeal, I am again persuaded that the appellant is correct. The Planning Commission did not properly consider the safety of Adams Willett Road or the connecting Hancock Run Road. The Planning Commission did not exercise due diligence in concluding that the requirements of the Adequate Public Facilities Manual were met. The county confirmed that Adams Willett Road and Hancock Run Road do not meet county standards. Adams Willett Road is between 16 to 18 feet wide within a 30-foot right-of-way, but to be compliant with our road ordinance, the road should be at least 22 feet wide with a gravel shoulder of 4 feet. Section 75C of the subdivision regulations state in part that, quote, the new development shall improve the road to the appropriate paved road section to the extent feasible within the county or state-owned right-of-way from the intersection of the point of access to the project to the first public roadway with a pavement of acceptable standard per the road ordinance, end quote. The county's position seemed to be that the zoning officer alone determines what is feasible. I disagree and suggest that the decision of what's feasible rests with the Planning Commission. The county also argued that the road cannot be widened at all because any modification to the roadway would trigger other rules and regulations, for example, stormwater management, that cannot be satisfied within the existing county right-of-way. However, even if we agree that widening the road to county standard is not feasible, Section 8 of the Adequate Public Facilities Manual instructs the Planning Commission to determine if the major subdivision is still in the public interest. The appellants presented compelling testimony and evidence that it is not. The appellant presented rebuttal evidence that even Route 426, Liverpool Point Road, does not meet county pavement width requirements. It is only 18 feet wide, as measured by Mr. Hastings. County staff did not measure that road during the review of the project. So the nearest roadway that meets county standards is therefore Route 6. That being the case, it is logical to conclude that 75C requires the developer should not only improve Adams Willett Road, but also Liverpool Point Road to all the way to Route 6. And there's no evidence that the county staff or Planning Commission considered the feasibility of improving Liverpool Point Road at all. The Adequate Public Facilities Manual specifies that roadway link analysis be done in accordance with the Highway Capacity Manual. During rebuttal, the county staff testified that a roadway link analysis was performed in preparation for our appeal hearing, and the conclusion of the staff's roadway link analysis was that Adams-Willett Road can support 1,650 vehicles per hour, or 27 vehicles per minute, with an 8-foot lane width. As I reviewed Chapter 8 of the Highway Capacity Manual, I noticed that the available calculation factors do not contemplate lane widths narrower than 2.7 meters, which is 8 foot 10 inches. No worksheets for the calculation used by the county have been presented into evidence. I cannot logically reconcile the county staff's testimony about the capacity calculation, 1,650 vehicles per hour, with the video and photographic evidence of Adams-Willett Road and Hancock Run Road. The appellant provided compelling evidence that the existing road infrastructure is not adequate to support a major subdivision of this nature without significant improvements to the roadway. Drainage improvements alone will not make the roadway adequate. Referring again to Section 8 of the Adequate Public Facilities Manual, the Planning Commission is charged with determining whether the public infrastructure meets or will meet county standards. The Planning Commission is also charged with the determination of whether approval of the proposed development is in the public interest. And the regulations give the County Planning Commission 3 choices. Either the facilities are adequate, so you grant approval, or the facilities are inadequate and approve some mitigation, or 3, that the facilities are inadequate and find that the mitigation is not acceptable, in which case the subdivision is not approved. There is no question that the roadway fails to meet the standard. Our question is whether they are adequate and whether proposed mitigation is acceptable. I conclude that the roadways in question are not adequate. Drainage improvements may be beneficial, but do not fully mitigate the substandard conditions of Adams-Willett Road, Hancock Run Road, and Liverpool Point Road. So it is my opinion that the Board of Appeals should reverse the decision of Planning Commission and deny the preliminary subdivision plan.
Mr. Moon, I agree as though you were in my head. Every word that you typed there and read back to this court is exactly how I feel. I would also add that there were several manuals that I'm sure that this court used. They used the Adequate Public Facilities Manual, the Subdivision Regulations, and the Charles County Road Ordinance. And in every case, it would always say the more restrictive design standards shall apply. And I believe that just by adding those culverts is not enough to take into consideration the public safety, the welfare of that, and the health of that community.
Well, thank you, fellow board members. I'd also like to commend Chairman Moon on his notes. Very thorough, and I would lend my name to endorse all of the points that you cited. Areas of particular concern, I will add, that probably troubled me maybe more than I saw other people react, and I think is a common theme that we're seeing, is that at the final and closing moments of some of these votes, and I've experienced it myself, you know, we're citizens, we come to serve on a board, so we're certainly not experts, we're not part of the PERMA staff, but at those final moments you can see some of the Planning Commission members asking questions about what they're supposed to be doing, and all the time a voice comes to them to advise them, and in this case inaccurately, that they it basically implied that they must improve the subdivision since one particular piece of criteria had been met. And in my judgment, when that is uttered by the attorney representative for the board, that's a bit outside the scope of what I see from comments like that, as well as the moving around with whether would it be voted, would it be put forward, is I don't see an attorney advising that board. I see somebody trying to steer the outcome, and that troubles me very greatly. Obviously, our attorney this evening has been retained to represent us from the outside, and seeing how that dynamic works, I think we have to be very careful that we don't let the fact that our attorney advisors often work in this building and know everyone in the building, they shouldn't be sort of steering the projects and the decisions. They should really just be advising the board legally. In this case, as the appellant makes very clear at the bottom of page 2 on their original appeal request to us, it appears from a novice watching of that video that there is an effort being made to steer the outcome and not provide legal advice. Because it seems pretty clear in the public facilities manual that we have a deficiency here, and so to have people at the very last moment on a third revote being advised that they have to, it's just not accurate as far as I'm concerned. And out of all the things that you mentioned, this is the one that troubled me the greatest, and I wish to underscore it. So with that being said, I leave everything else that you said with my endorsement as well. I followed the case with very similar fashion, and I will not repeat my notes to add weight to yours. Yours are better than mine. That's all I have to say.
Mr. Meacham, would you have any comments or advice that you would want to share with our members before we make a motion?
No, thank you.
Okay.
Mr. Chair, if it's okay with you, I would like to have the honor of moving that we set aside the approval as a result of our review of this appeal.
Okay. So I believe that's a motion to reverse and deny?
That's correct.
Is there a second?
Second.
Any other discussion? All those in favor?
Aye.
Aye. No opposed. All right. So that concludes docket 1376 for Washington's discovery. All right. Thank you.